But the agent for the buyer says that I can't get over today. I have the cashier's check. I can show you a copy of it, but I can't physically hand it to you until tomorrow. What do you do as an agent, the buyer's agent? What would you do? I mean, no, you're the seller's agent.
Get an addendum. Do an addendum.
Do an addendum. And absolutely. If you don't do an addendum, and this is what happens, what could happen. Your buyer, that buyer's agent says the next morning, oh, Trent, by the way, my buyer decided he doesn't want to buy the property. And now you don't have an earnest money deposit, and the buyer has decided not to buy it. You didn't tell your seller. Your seller should be the one deciding whether that buyer has breached the contract or not. It should not be you. Don't you ever make decisions for your clients. Your clients make decisions for themselves. You present the evidence, you present the facts, and you let the clients make the decision. If they're not going to have it in by today, the 5th day, you need to call your seller and say, hey, the buyer's not going to have the deposit by the 5th, which is at 11:59 tonight. What do you want me to do? The seller may say, put it back on the market. Or the seller may say, then I want an extra $5,000. You need to let the seller make that decision. Or the seller may say, if they don't get it by 11:59, I'm going to accept that. Then we have another person interested, call that other person. So you make that, let them make that decision. That makes sense? All right. Yeah. All funds paid by the buyer, including deposits, will be paid by check, cashier's check, or wire funds. Now, this does not say certified check. It says cashier. We do that as a difference. A cashier's check is guaranteed by the bank. So make sure it's a cashier's check. Wire funds, there's still companies that they don't want money wired. I didn't for many years. My agents told me I need to get out of dark ages. So now I do allow money to be wired, but for years I wouldn't. So if you don't want wired funds, or your office is not, your broker doesn't want money wired in, then make sure you cross that out, because it's in there and you can't then sign it. And then the person says, I'm going to wire it. And you say, we don't permit it, but you've already got it in the contract. So if you're not going to allow wired funds, make sure you cross that out. All funds paid within 30 days has to be paid by cashier's check or wire funds, not by personal check. Obviously, that's there because you want to make sure a personal check has time to clear. 30 days is more than enough time for a personal check to clear. So just make sure if it's there. Now, it's up to your broker, it's up to the seller. If you all agree to take a personal check in less, but I don't think it's a good idea to do it. Seller concessions. No, I'm sorry. C, deposits, regardless of the form, would be paid in U.S. dollars to the broker for the seller. Now, this is the default position here is that the broker for the seller is holding the escrow deposit. You can change that. There are offices, there are companies that don't hold escrow. We just got one. One of my agents had an offer yesterday, and they said we don't hold it, so they wired into my escrow account. So if you don't hold it, then what I don't want you, if you hold it, you can just change it from broker to seller, maybe broker to buyer. All right. But the one thing that I want you to be mindful of, there are a lot of times I'm seeing people want title companies to hold it. I'm not a fan of a title company or an attorney holding escrow. And I'll tell you why. Let's say if a title company is, I'd suggest you put the name of the title company, not just title company. ABC Title Company. Put the name of the title company. I'll put an address. People should know, buyers should know where their money is. Because if there is a dispute, they need to know who's holding their money. They need to know who's holding their money anyhow. Remember, the deposit money notice tells you who's holding it. So if the title company is holding it, I would put ABC Title and the address. I would even put a phone number. And if there's an attorney, don't just say attorney for buyer or attorney for seller, put the name of the attorney, John Smith, attorney at law, and the address. I will put a phone number because, again, I should be able to identify or be able to locate my money anytime. I should know who's holding my $5,000, $10,000, $15,000 earnest money deposit, especially if there's a dispute, okay? If this doesn't go to closing, I definitely need to know who has my money. But here's the reason I don't like title companies or attorneys holding escrow, because the licensing law and the rules and regulations of the Real Estate Commission make it clear what brokers can do if there's a dispute. If there's a dispute, if let's say there's a dispute about who's entitled to the escrow monies, the title company, they're not bound by the rules and regulations of the Real Estate Commission or the Real Estate License and Registration Act, any licensing laws. So the title company attorney are regulated by some other agencies. We don't know what their decision, how they will make a decision as to who will get the money or how they determine it. So if a title company or an attorney is holding the escrow, at least get a copy of the escrow agreement so you know what happens in the event of a dispute. I will never let that happen, because I only want a broker holding it, because if there is a dispute, let's take a look at this. It says that here it says that the deposits, regardless of the form of payment, we paid in U.S. dollars to the broker for seller, who will retain deposits in escrow with all in conformity with all laws and regulations until the contract has been completed. And it says only real estate brokers are required to hold deposits in accordance with the rules and regulations of State Real Estate Commission. So brokers, if a broker is holding it, let's go to paragraph 26B. If a broker is holding the escrow, I know they can't make the decision as to who's entitled to the escrow. There are only one of four conditions under which a broker can release that escrow. An attorney may make a decision who's right or who's wrong. The title company may, I don't know, but a broker cannot. That's why I want only a broker holding the escrow. Take a look at this. It says, regardless, 26B, regardless of the apparent entitlement to deposit monies, the Pennsylvania law does not allow a broker holding deposit monies to determine who is entitled to deposit monies when settlement does not occur. Broker can only release deposit monies. One of four things must happen. One, there was no dispute. If the agreement is terminated prior to settlement and there's no dispute over entitlement to deposit monies, a written agreement signed by both parties is evidence that there is no dispute. So the broker gets a termination agreement sale and the distribution of funds, and says, give the money back to the buyer. Let's say the buyer did a home inspection, wasn't pleased with it, and we terminate the contract and the broker returns the escrow to the buyer. But you still have to have something in writing. And we know there's no dispute if both the buyer and the seller agrees that the money goes back to the buyer. Number one, there is no dispute, so the broker can release the money back to the buyer. Number two, there was a dispute, but the dispute has been resolved. If after the broker has received deposit monies, the broker receives a written agreement that is signed by both the buyer and the seller directing broker how to distribute some or all of the deposit monies. Well, maybe there was a dispute, but the buyer and the seller agreed that they're going to split it, or one party is going to get 75, the other is going to get 25, but they've come to an agreement. Well, now the broker has an agreement signed by both the buyer and the seller. The broker can then distribute the monies according to that agreement. Number three, the broker can only release the deposit monies if there is a final court order. And the key word there would be final, with no further appeals. There's a final court order. I get a final court order saying that the deposit money goes to the seller. As a broker, I'm able to release that money to the seller. And the fourth one, we call it a prior written agreement. Number four says, according to the terms of a prior written agreement between the buyer and the seller, that directs the broker how to distribute the deposit monies. If there is a dispute between the parties that is not resolved, then the buyer and the seller have already agreed in advance as to how this money will be distributed in the event that there's a dispute. Now, where is this prior written agreement? You see it says, see paragraph 26C. Well, there is your prior written agreement. 26C is your prior written agreement. It says buyer and seller agree that if there is a dispute, remember, there is no dispute yet. They just signed this contract, but they are making an agreement in advance in the event that there is a dispute over the entitlement to earnest money deposits. So buyer and seller agree that if there is a dispute over the entitlement to deposit money that is unresolved. Now this says that the default position is 180 days. I can't tell you what to put in the contract, but I think 180 days is an awfully long time. So I'm just going to put 30 and read it again. Buyer and seller agree that if there is a dispute over the entitlement to deposit money that is unresolved 30 days after the settlement date or following a termination of the agreement, whichever is early, so either after the settlement date or following the termination of the agreement, whichever comes first, then the broker holding deposit monies will, within 30 days of receipt of the buyer's written request, distribute the deposit monies to the buyer. All right, let's stop there. So if there is a dispute and you put, for instance, 30 days after the settlement date or the termination of the agreement, whichever is earlier, then the buyer sends a notice to the broker asking that broker to release his or her earnest money deposit because there's a dispute. And all right, but what has to happen in order for that broker to release that money? Let's continue. It says that the broker, if the buyer does it within 30 days, I'm sorry, let's go back. I'm having a problem seeing this. Buyer and seller agree that there's a dispute over the title money, over the entitlement to deposit money that's unresolved. We said 30 days after the settlement date or following termination, which is early. Then the broker holding deposit monies will, within 30 days of receipt of the buyer's written request, distribute the deposit monies to the buyer unless the broker is in receipt of verifiable written notice that the dispute is the subject of litigation or mediation. The only way the broker cannot release that money once that broker receives a written request from the buyer is if the seller has already initiated litigation or mediation. Verifiable, it says. Not you say, seller says, I'm gonna file a lawsuit. No, that doesn't count. So if the broker has not received any verifiable notice that there is a mediation, that the seller has initiated mediation or litigation, then that broker must, within 30 days, return that money to the buyer. All right. And now, if let's say the broker gets a letter today, and then the seller finds out. Now, remember, the broker has 30 days to get the money back to the buyer. The seller finds out, runs down, and initiates mediation. Would the broker still send that? Would the broker have to give that money back, or would the broker have to hold on to it?
The broker has to hold on to it.
Why? Why is that, Watson?
It's being disputed.
All right. Now, but the answer is no. They have to still give it to the buyer because remember, this says that the buyer, once the broker receives that written request and the seller has not done anything, basically, then the broker must give that money. It can't be an after the fact. It can't be, oh, I learned that that the buyer just sent a letter requesting the earnest money deposit. Well, they're not entitled to it. Don't send the money. Well, it's too late because you should have done something before, not after. So in that case, the broker should still give that money back to the buyer. Now, if you go down further, buyer and the seller agree now that distribution of deposit monies based upon the passage of time does not legally determine entitlement to deposit money, and that the parties maintain their legal rights to pursue litigation even after a distribution is made. So I can still sue. So just because the buyer gets the money back, the broker releases the money back to the buyer, it doesn't say the seller can't then still later initiate litigation or mitigate litigation. So, but I would rather have the money in my bank account than in the broker's bank account. Any questions about this? Any comments? How many of you just don't care? You want me to just end
Oh
this?
man,
I don't know how many people on that. You're listening. Is this boring you all?
I'm listening. I'm listening.
I'm in
I'm
Florida.
taking
It's
notes.
85 degrees
Taking
today,
notes,
and I
man.
can go back over to the beach.
No, we
I'm
are
listening
continue.
loud and clear.
All right.
Notes.
There's one person listening because it's warm here, and I've got one more weekend in Florida, and it's 85. So if you all want me to quit here, you want me to end there?
I have a
No.
question.
Oh, no.
No,
No, please.
All right.
please
Two
no.
people want me to go on, so I'll go on. All right, let's go back.
Trent, before you
Yes.
continue, I just need to make a comment here. So for our members, if you ever run into a dispute regarding the deposit monies and you are within that time period, if the property is located in Philadelphia County, you would contact GPAR. And that's me.
And then, so Cheryl, hold on one second while because I was going to ask you here, Cheryl, here it is, paragraph 27. Go on, Cheryl, talking about the contract says that the buyer and seller should submit all disputes or claims that arise from this agreement, including disputes and claims over deposit money to mediation. Go on, Cheryl.
Correct. So that 30-day time period, all right? The buyer says, they want the deposit monies back, but the seller says, no, I want to keep the deposit monies. Well, now you have a dispute and you're within that 30-day time period. So that verifiable notification for mediation is going to come from GPAR. You'll notify me either by email. My email address is cheryl@gpar.org, or you'll give us a call, 215-423-9381. I am option number 3, and say, hey, I have a dispute. My buyer is requesting, mediation. Properties in Philadelphia. If the property is not in Philadelphia, if it's in Bucks County, you'll have to notify the Bucks County Association of Realtors. If the property is located in Delaware County, Chester, or Montgomery, you'll have to notify Tri-County Association of Realtors. And then what happens is I would email to you the dispute resolution transmittal form, in which you'll have your client fill out. Also a list of potential mediators. You would then send to me, there is a $100 non-refundable filing fee that your client would have to pay to file for mediation, and send everything to me along with a copy of your fully executed agreement of sale, which has that mediation clause included. And then I notify the other party so that your client is requesting the mediation.
Okay.
I have a two-part question regarding that. One, if there's a dispute and the property is being put back on the market, can that property be sold while there's a dispute?
Okay, are you Cheryl? Are you Michael? You direct that to Cheryl?
Either one of you.
Yes.
Yeah, either one of you. So there's a dispute that the buyer pulled out. He wants his deposit back, and the seller decides to go back on the market with the property, or whichever way that goes. Can it still be sold while there is a whole dispute and mediation going on?
I think
I
that
understand it.
depends.
Yeah, that would be a paralegal question.
Yeah, I think that's a legal question because the thing is, what pops in my mind, what if the buyer wants the property?
Right.
And so if you put it back on the market and you sell it, well, the issue may be the buyer still wants to force the seller to say, maybe they're going to sue them for specific performance. So I think you would need a lawyer at that point. I personally in my practice, I've always wanted to resolve it before I put it back on the market. Unless the seller, we know the buyer didn't want it. They're like, listen, I definitely don't want it. But
Right.
The only issue I have I need my money back. But so I still would think that's a question to talk to your broker about, because it depends on the situation or an
Okay.
attorney. But yeah, I would, because I don't think I think every situation could be different.
Okay. Thank
But
you.
You're welcome. All right, Cheryl, you done with that? You good?
Yes.
All right, so
Yes, I'm
everybody, you see mediation. So you know that if there are any disputes, we go to mediation first. It does say, well, I'm gonna leave it at that, mediation. And Cheryl is the best. They don't get better than Cheryl. All right, let's go back up to seller concessions. And it's funny that people make a lot of mistakes with this, and this is something that's changed with the NAR settlement. The seller concessions is broken down to two: a buyer broker fee and a closing cost. A buyer broker fee is the commission. Just look at it, the commission. The closing cost assistance is your seller assist. Well, we know a seller assist. If you just remember that way. Now, here's where, and it's funny, I just got a contract last night and the broker did this. I'm just gonna make up numbers. All right. I'm just making up numbers. I'm gonna tell you what I'm paying people. All right. He put it wasn't 100,000. I was trying to put 10,000. He sends me, he does this. He puts, let's say, 10,000 in here, but he also sends me a cooperating broker compensation agreement that has 10,000. Well, that means he actually wants 20,000. This is what you need to, please, I want you to hear this. You use one or the other. You don't need both. There are situations where you need both. Let's say that the broker compensation is 10,000. If you put it here, you don't need the cooperating broker compensation because it's already here. It's in here. The seller, it says that they're going to give you 10,000. But look at this paragraph. It says, in addition to, not this is in addition to any cooperating compensation negotiated between the brokers using the cooperating broker compensation or by some other arrangement, seller will pay the following. In addition to, so if you already negotiated 10,000 and you have the cooperating broker compensation form, but you want 12,000, then you would put 2,000 here because you've already agreed to 10, but you want 12. Does everybody understand that?
Yes.
You wouldn't put 12 here and then 10 in the cooperating broker because then you're asking for 22. Either if you all negotiated again 10,000 and the buyer, you're okay with that and the seller's willing to pay that, then you don't need the cooperating broker. But if you have the cooperating broker and let's say you agreed to $10,000 commission and the cooperating broker compensation form, then you leave this blank. Does everybody understand that?
Yes, I got you.
All right.
Please
Now-
repeat
No,
that.
can you,
I'm
no,
so
can you just,
sorry.
yeah, sorry. Yeah,
please
can you
repeat
repeat it
that.
just one time?
All right. Let's say let's say they're offering $10,000 corporation compensation in this, they're offering 10,000 as cooperating broker compensation. You write up this contract today and you call the agent says we're offering 10,000. You put 10,000 here. You're good. You don't need the cooperating broker compensation form because the 10,000 is listed here. But let's say you don't know what the broker is offering because you couldn't get him or her. And you used it. Well, not gonna say no. Let's say you got the agent, and the agent says we're giving 10,000, and you all sign the cooperating broker compensation agreement. Then you wouldn't put anything here because you either use this line or you use a cooperating broker. You only use this if there is a difference. So let's say they're offering, you all agreed to 10,000 in the cooperating broker compensation agreement, but you want another 2,000. So you put the 2, and let's say they agree to give you 2. So now they're giving you 12, the 10 that's in the cooperating broker compensation, and the 2 that's here in the agreement of sale. Does that help? Does that clear that up?
Yes.
I have a question. So if the commission is a straight 5%,
Yes.
that's what's been negotiated, it's 5%. that
Yes.
5% will go on line 24, 3A, line 24, 5%, okay? Now,
Yes.
of that 5%, if 1% is being paid to the buyer's agent,
Wait, wait, so 1%
okay,
is going to, wait, how much is going to the buyer agent?
I'm sorry, 2%. If the 2% is going towards the buyer's agent, okay,
Okay.
so 5% total, 3, 4, let me take this out. 5% total,
You don't
3%
care
is
about the total.
for
You just care
what,
about what the
what,
buyer
but,
agency is getting. What are they
but,
getting? The 2%?
okay, okay, yes, the buyer's agent will be getting 2%. So
Right.
that 2% is going to go where?
Right here. Can you see it? Line
On,
25.
on line 25, paragraph 3, line
Can you,
25, paragraph
are you not able
3B?
to, can you not see the agreement sale on the, I
Yeah,
just put the 2% in there on line 25. You just put the
okay,
2% there. Do you see that?
okay. Yep, I see that. Now I'm representing the seller, so for my 3%, that 3% is going to go on
Nowhere,
line
nowhere,
nowhere.
nowhere. It does
Okay.
not go in this
Oh,
contract.
that's right, because it's the agreement of sale. I'm sorry. That's right.
Right.
That's correct.
Yeah,
Okay,
the agree,
so
because your 3% or whatever it is,
that's
and we shouldn't
separate.
use numbers. Let's not use real numbers, make up numbers.
Yeah,
Let's say your 10%, because you're a fantastic agent, your seller's giving you 10%, it would
right.
be listed in the listing contract. It wouldn't
Correct,
go in the
correct,
agreement of sale.
correct. Right, right. Now this is just what's being entered in the agreement of sale. Now, when is the cooperating broker's compensation form being used?
It wouldn't need to be used if you all agreed to 2%. It's not necessary.
Okay, but when
It's
would it
only
be?
necessary if you change, if it's something, remember, this says in addition to the cooperating
Mhm.
broker, you get in this. If I have a cooperating broker and it says I'm giving you 10,000 and I'm happy with 10,000, I put nothing here. I don't need
Okay,
it. I don't need to put anything. Or
okay,
if I didn't use a cooperating broker and you told me I'm giving you 10,000, then I would put it there and I wouldn't need a cooperating broker. I'm only using it to add to it. So if
okay,
if I'm getting 10 that's in the cooperating broker, but I want another 10, then I will put that here. Now, of course, the
okay.
agent can come back and say, no, we'll give you 3, but you can
Right,
negotiate. But you're not going to you don't need the cooperating broker if you have put if the buyer broker compensation is here and it's been agreed to. You don't need it because then you're actually saying, I want 20, I want 10 that's in a corporate broker,
right,
and I want 10,000 here. So
right.
using one or other. Now let's go to the second one because people kind of get confused with this. The closing cost assistance is what we really know as a seller assist. Now, let's say let's say your buyer is supposed to pay you 15,000. Let me just write this down. You go in your buyer agency contract, you want a fee of 15,000 from your buyer. The seller, you ask for a commission. The buyer is asking for a $15,000 seller assist or seller contribution. That 15,000 can be used to pay closing costs and or the buyer broker fee. So the buyer, let's say that you owe, well, let me change. No, let's leave it there. So the buyer is giving you the seller is giving 15,000 for closing costs. It could be split, it could be used however the buyer chooses, as long as the lender approves. That's what you want to remember, because the lender, you make sure that you check with the lender before you use any of that 15,000 to pay all or part of the broker's compensation. Because some lenders may have policies that won't, they may have it only allow a certain amount. So check with the buyer's lender. Say, hey, I have a buyer agency contract with this buyer who has to pay me a fee of 15,000. They get in a closing cost assistance, and they don't really need it, or they need 5, they don't really need it. Let's leave it that way. And they get in 15,000 closing costs. Can the buyer use that whole 15,000 to pay my fee. The lender may say, no, they can't use the 15, we'll allow you to use 10. So then the other 5 would be used to pay down the buyer's closing costs because they can't use the whole 15. But all I say there is check with the lender. Any questions there? All right. All right. Well, let's go on to paragraph 4, settlement date. Make sure, and here's something that just drives me nuts. Okay. It just absolutely drives, and this is real. I remember years ago, I got a contract, and that was a settlement date. Anybody have a problem with that date?
Yeah, banks are closed, the holiday, it's part of fine people. Yeah.
Yeah. And when they sent it to me, it happened to be on a Sunday. The 4th of July fell on a Sunday. So not only could you not have closed, even if it was not the 4th of July, when you write up these, I always call them, don't be a sloppy agent. The 4th of July, December 25th, there are weekends, have a calendar in front of you and make sure they're on some religious holidays where banks may be closed. Some banks, I don't know, Veterans Day or Columbus Day or whatever it's called now. You just make sure that you understand the dates, because don't give somebody a contract with the 4th of July or Christmas Day or Thanksgiving Day. All right. So just make sure. Now the agreement the contract says it has to close on before. Let's change it to, I don't want this 4th of July. Let's say it's on before May 15th. It can close before May 15th, but if you're going to do it before May 15th, most agents don't do it. I still would get an addendum changing it to the that means we can close up to the 15th, but if you're going to change it to the 13th, you're going to close on the 13th, do an addendum saying buyer and seller agree to change the settlement date to the 15th. We have the change in terms form you can use, but a lot of times we just excited and we know that has to close before the 15th. I believe that if you should always protect yourself. Don't get excited. Always keeping, this is how I've always thought of this. If someone needs to see my file, if I'm being sued, which I've never been, or I have a complaint filed against me, which I've never had, if someone needs to look at my file, what will the story be? Will they be able to tell what happened in this transaction? That's how you should focus. You should look at this. Don't just leave things blank, leave things out. If you're going to, just always cover yourself, all right? Settlement has to occur in the county where the property is located or an adjacent county, okay? So if the property is in Philadelphia, you can't say we're going to close in Harrisburg. Now, both parties can agree to do Harrisburg, but you can't expect the seller to show up in Harrisburg if the property is in Southwest Philadelphia, all right? Unless you agree. Who pays the taxes on, and what's like the local custom here? Who pays the transfer taxes? Paragraph F. Payment of transfer taxes will be divided equally between the buyer and the seller, unless, of course, remember everything in the contract is negotiable, or in this offer is negotiable. So you can make the seller pay it, you can make the buyer pay it, but our local custom here, we split it. What are the transfer taxes in Philadelphia? What are the total transfer tax? Anybody know?
No.
4.278%. 4.278. I think that's, is that right? 4.278. And how's it broken up? 1% always goes to the state, and then 1% will go to, and then 3.278 would go to the city. Does Philadelphia have the highest transfer tax in the Commonwealth of Pennsylvania? Does anybody have higher? Anybody on here from Pittsburgh? Pittsburgh is 5%.
Oh, goodness.
All right, but we don't have the highest. We have the second highest. We're 4.278. Pittsburgh is 5%. Split equally between the buyer and the seller. Again, everything is negotiable. Here's something else, paragraph G, where a lot of agents kind of not know this is here. Look at this. Possession is to be delivered by deed, existing keys, and physical possession to a vacant property free of debris. You don't need to put in additional terms that the property has to be broom swept clean or whatever I see. It has to be vacant. You don't have to put that because paragraph 4G already does it for you. It tells you this property is being delivered to the buyer. It has to be delivered, a vacant property is to be delivered to the buyer free of debris with all structures, keyword all, backyard, side yard, front porch, all structures, broom clean at the day of time of settlement. You can't put all your junk in the backyard. You can't pile your old bedroom furniture next to the side of the building. You need to make sure everything is off the property. All right, everything, all structures. Backyard is part of the structure. All right, everything, all real estate, all real property should be broom swept clean. So don't have to. So don't put that. I can tell you every time I sell a property as is, somebody sends me, puts in there that it has to be broom swept clean. They put this language in, and I always remind them that we have to deliver it to you this way. You don't have to tell us it has to be delivered. All right. Any questions or comments? Are you all, is this helping anyone?
Yes.
Yes.
All right. So the two of you,
Yes.
thank you for the two of you who is
Yes.
helping. I don't know how many, how many people on? Can somebody tell me how many people on this? I can't see.
Says
Yes.
37.
37.
37. All right. So 2 people helped out of 37. All right.
Three.
I think I'm not a gambler. All right.
too.
Let's go on. I'm sorry, 3. Let's look at, go down to, let me ask a question to you 37 people, the 2 or 3 of y'all who was responding. If I am selling, if you have a buyer and your buyer is, now I say you represent the seller, you're selling a triplex. The 1 unit is vacant. Settlement is the end of April. 1 unit is triplex is vacant. Can that seller put a client in this property, a new tenant in that vacant unit without the buyer's permission?
No.
Anybody say yes?
It's possible for sure.
Okay, how is it possible?
Because there's no language that says that they can't do that.
All right, well, I would
Was there
say
an
you're wrong,
addendum?
but okay, well, let's look at
Just
it.
say no.
There is language that says it, and I look at paragraph 4H. Let me go down, take you down to seller will not enter into any new leases or short-term rental agreements, nor extend existing leases or short-term rental agreements for the property without the written consent of the buyer. So the answer is no, because keep in mind, Michael, what if your client wants to move in that unit? Why maybe they buy this triplex because it's going, what if they get an FHA loan and this has to be their primary residence? And now you go and put a client in there, a tenant in there. Well, now the buyer's like, well, I don't want the unit. I'm going to move in there and I'm getting an FHA loan, which means I have to use that as my primary residence. I could not have qualified for an FHA loan if that was not, I wasn't going to use one of those units as my primary residence. Now I'm actually an investor, and I'm so the answer is you cannot, and you have to make sure you tell sellers when you're selling multifamily units that they can't extend leases, they can't put they can't put 10, they can't do anything without the consent. Now, if I'm an investor and you come to me and says, hey, Trent, I know someone who wants to buy, you rent this unit for $4,000 a month, and I'm an investor, I'm gonna tell you, sure. But if I need to live in it, or if you come to me and say, I'm putting my daughter in there and the rent's gonna be $100 a month in a property that's in Center City, then I'm gonna tell you you've lost your mind.
Thank you,
All
sir.
right. All right. And if it's tenant occupied, you should use a tenant occupied. You would check that box and use a tenant occupied property addendum. Here's one thing, that if you're selling a property that's a tenant occupied and you don't have the leases, the tenant occupied property addendum says that you have to provide a memorandum, which basically let's say there's a verbal lease, you should put it in writing saying, okay, the tenant's rent is this amount, they're responsible for water, for light, gas, and I'm responsible for water. They put a security deposit down of $2,000, and this landlord should sign it, the seller / landlord. One thing that I've always thought was odd where they never get the tenant to sign that memorandum. I want tenants to sign it because let's say the landlord says there was $1,000 security deposit, but the tenant actually put down $3,000. So now when the tenant, now you buy it, the tenant now, the lease ends, the tenant says, hey, Michael, my lease ends, return my $3,000 security deposit. You say, no, there was only, according to the landlord, you only gave $1,000. They said, no, here's a copy of the cashier's check. When I moved in, it's $3,000. You better give me my $3,000. You're going to have to give that person that $3,000. I always want the tenant to verify the amount, well, the terms. I want the tenant to tell me that they're responsible for everything, including water. I want the tenant to tell me that the security deposit was this amount and they also paid last month. I want the tenant's signature so we don't have a problem. That makes sense?
Yes.
Yes.
All right.
Yes.
All right, written consent. I mean, written acceptance. If you write a contract, you give them the date. This is when this seller must have signed it. Obviously, if there's a counter, the seller can mark that out and they can give a date that you have to. If you don't sign by this date, then this contract is just expires. All right. So don't put a date if you know is a popular property and you put today's date and you're not giving full price, then I don't care what's in that date. My seller won't care because you giving me is a hot property. You giving me until the date is signed, my seller to the date is sign it, and we getting all kinds of offers in. Well, you may, let's say, okay, and you're not even giving us full price. Now, if you give me a really good offer, and I remember once someone gave us $100,000 above list price. I don't care what was in here. I told the seller, you stop what you're doing, you sign this, and you get it back to me within 3 minutes. Because we don't want the buyer to change his mind. All right. So when you use this date, make sure that you give the seller enough time. But if it's a really hot property, most people could care less about that date because unless you're giving them a really good offer. If I'm giving a really good offer, this is what I do. I say March 25th by noon. All right, or by 11 a.m. That's it. This is good till this offer is good till today at 11 a.m. I'm not giving it longer than that because then my offer may change. If the offer is really good, I'm not waiting for you. We're not going to allow the seller to hang on to see if they can get a better offer. Nope. Either you accept this really good offer by 11 a.m. or it goes away. And maybe I say, okay, it's 11. Now we're going to just change the offer. All right. Any questions or comments?
Trent, here's a question from Joshua. Would the seller have to transfer the security deposits collected to the buyer?
Yeah. Well, the seller, yes. When you buy a multi-unit, whatever security deposits that the seller is holding, remember, seller should have that money in an escrow account. The seller has to transfer those that security deposit over to the new owner, the new buyer. Absolutely, because remember, when the tenant leaves, the tenant's not going to the previous owner. They don't know where they are anymore. They don't own the property. They go on to you, the current owner, saying, hey, return my security deposit and you better have it. Right?
Okay, I believe you did answer this question going back to the co-op section of the agreement. When do you use the co-op broker form and when not? Question from Kat.
You use it when you negotiate. You can use when you're negotiating the broker service fee. If you were to call the broker today, you're about to show a property. I get calls all the time. How much? What's the broker compensation? And I may say, let me say 15,000. Then we know it's 15. They would put 15 in incorporate broker compensation, send it over, and I'll sign it. So now we have an agreement that's 15,000. If for some reason you couldn't get me, so you don't know what the compensation is, if any, and you submit an offer, you would just put the 15,000 here and hope that's what you want. And I could then get it and come back and say, no, it's 10,000 or it's 8,000 or whatever, but you don't need both. You have one or the other. If you put the 15 here and the seller agrees to it, then you wouldn't need the cooperating broker. If you put nothing here and just had the cooperating broker, if you all agreed up front, then you wouldn't need to put anything there. You tilt one or the other, or like I said, or if they're changed, let's say the cooperating broker, you agreed to 15, but you're like, you know what, I thought about it. I actually want another 5. Then you would put that there because that's an addition to. You already agreed to 15, but now you want another 5 because maybe your buyer has to pay 20 and your buyer says, hey, Trent, I want you to see if the seller is willing to pay you the other 5 as opposed to me having to pay it. So I now try to negotiate another 5 on behalf of my client.
Okay, and so we have an opinion from Mark. For simplification, we should just get rid of the PA form CBC and
I
just
agree.
spell it all out here,
I
especially
agree.
since it's just another negotiable item between the parties, and the CBC could potentially still give a perception of collusion.
Well, I
Just
agree
his-
that we don't, I don't think we need it. I agree with Mark. I don't think we need it. I've never used it, so I don't use it. I call the agent and I find out what the compensation and I put it in the contract. I think it's confusing, and I know it's confusing because I got a contract just last night, like I told you, with the CBC, and the agent had texted me and asked me what's the cooperating compensation. I told him. He put in a contract and he sends me a CBC. And I had to tell him, you know, you didn't need the CBC. I'm not signing that because you put it in the contract. So, and this is not a new agent, okay? I know this agent's been around for probably 10, 15 years. So clearly people still are confused by it. I think it's confusing. I don't think it's needed, but that's not my decision. But I think it's confusing. I really do. So I agree with that. I think it's confusing. All right, let's keep going.
Wait, we have
Sure.
I'm sorry, Matthew, you could go ahead.
So if you're a buyer, obviously you have to honor all the leases that are in place with the renters when the seller's selling you the place, correct?
Right. Yes.
Okay.
You have to,
Okay.
it's still, because remember the lease was between the original landlord and the tenant. They're just being assigned to you. So those leases, you still have to honor all the terms of those leases.
Right. If they got 10 months left, after settlement, they're with you for another 10 months.
Exactly. You can't
Okay.
buy and decide, I'm gonna raise the rent and the lease doesn't
Right,
expire
right.
for another 10 months. You couldn't do
Gotcha.
that. You have
Okay.
to honor those leases.
Thank you.
You're welcome. Go on, Cheryl. Did you have somebody else?
Let's see, we have a question from John. Does stones in the basement from a rubble stone wall have to be removed at the time of settlement?
There's a what?
Stones in the basement
Is a part of
From
a
a-
wall? Is
from
that?
a rubble stone wall have to be removed at the time of
I think
settlement.
it depends on whether we know there's a difference between a fixture and personal property. It depends on which it is or how the seller is treating it. If it's attached, and I don't know how, if it's attached and is treated, if it's attached and being used as a fixture, as a permanent part of the property, then as a part of the property would be, part of the real property wouldn't be removed. If it's personal property and being used as personal property, then I believe it should be removed. Or what do the parties agree to? This is what I think agents ought to do in situations like this. If you're not sure, if you think it's going to be an issue, you should put that in the contract. That fireplace in the basement that's really personal property is being kind of used. Is really real property being used. Again, cover yourself. If you're not sure, put it in the contract. Say, this is not included in the sale. And that's what we get into next. Well, if you look at paragraph 7, you can include, if you see 7B, the things that are included, what we go over. And if you wanted to add something, you could add it there. Fireplace in the basement. All right. Or if you wanted to exclude it, you could you could exclude it on D, fireplace in the basement. But I think that if you're not sure, I always err on the side of caution. Go with right included. Don't ever assume. Even things that that's personal, that's personal property, or it's, but they're using it as a fixture, as a permanent part of property. You should make sure. I don't ever assume anything. Okay, I want everything. I always tell people when I get the settlement, I call it a celebration. Okay, it's supposed to be fun. It's not supposed to be an issue. I don't want an issue. Let's resolve issues before we get to settlement, because I want to walk out with my check. Okay, I have bills I need to pay. I don't want this screwed up at the settlement table. I want us having, this is the time for us to celebrate, not to be arguing about something in a basement that you took that you shouldn't have taken. All right, let's go to paragraph 6, zoning. There's a zoning, if you have, now, this is another thing I keep saying to you. Even though zoning does not have to be included, the zoning classification, if it's zoned as a primary residence. Take a look at this. Failure of this agreement to contain the zoning classification, except in cases where the property is zoned solely or primarily to permit single-family dwellings, will render this agreement voidable at the buyer's option. Here's what I believe. I don't care what the zoning classification is, I would put it there. Again, I don't leave blanks. Even though you could technically leave this blank if it's zoned as a single-family resident, if it's zoned as single family. But even though this is a single-family zoning classification, I would just always, now, if you leave it blank, now, let's say it's zoned commercial. If you didn't put that, the buyer could come back and say, I'm going to void this contract. Anything other than single-family zoning classification has to be here. But I'm of the opinion that things should be blank, that even if it's a zone single-family, and we know on RSA 5 is single-family zoning, I would still put it in. And again, why do I say that? And I've always taught agents to do this, because here, I don't know if it looks like this. I don't know if you left it blank intentionally or you forgot to put this in. Now you've got a problem. You left it blank. You meant to put this commercial zoning commercial classification, zoning classification, but you left it blank. Now the buyer can void this contract. It's better to me, no matter what the zoning classification, just put it in there. Does everybody agree with that?
Mm-hmm. Yes.
Yes.
All right. Look at fixtures and personal property, which we're just talking about. It's everything that's included in the sale is listed, and they basically got everything here. You've got all things permanently attached, free of liens and others. You got the hardwired security systems, thermostats, lighting fixtures, including chandeliers and ceiling fans. Those are the problems. I always call this the chandelier section, because that's where you run into problems. People think that they can take that antique chandelier down in their dining room and replace it from something they got from the dollar store. You cannot replace a chandelier unless you tell the buyer up front, because whatever was there when the buyer looked at that property and decided to make an offer should be there when that buyer comes back to do his or her pre-seller walkthrough. If you're going to remove a chandelier, and I've had buyers, I remember a property in Haverford, it was a beautiful chandelier. They said, we want to take it. First thing I ask the client is, remove it first. In this case, they said no. Then the second thing I say, tell me what you're going to replace it with specifically. Go find the chandelier. Give me the size. Give me the number. Give me give me all the specifications so I can put together an addendum saying that the seller will remove the chandelier and replace it with this brand, this model, this color, this size, blah, blah, blah. Seller signs it, buyer signs it. Now, when the buyer comes back, they see that chandelier, they know exactly should be there. Don't put things like seller will replace with a comparable chandelier. And I remember years ago, a woman an agent put that, and I called her and I said, what the heck is a comparable chandelier? This is an antique chandelier. You're going to take this down and put another antique chandelier up? She says, no. I said, well, then, and they didn't want the chandelier. They thought it was ugly, but it was a chandelier, it was an antique. But I said, well, why don't we tell us exactly, why don't we find what we want up and we'll agree to it. And she said that was fine. But so it's best to have, exactly what's going to be replaced. That ceiling fans too. Make sure you're not removing ceiling fans. If you are going to take the chandelier, you should put it, you're excluding the chandelier. I know I misspelled it, but that's all right. All right, so if you go back up, you got the chandelier, lighted, pools, spas, and hot tubs, including the covers and the cleaning equipment should be left. Electric fencing, animal fencing, including the collars, garage door openers, transmitters, mounted brackets and hardware for television and sound equipment, unpotted shrubbery, anything you can cross out. You able to just put a cross out, anything you're not going to leave, planting and trees, smoke detectors, carbon made to be there, sump pumps, storage sheds, fences, mailboxes, wall-to-wall carpeting, existing window screens, storm windows and storm screens, storm doors, window covering hardware, including rods and brackets, shades and blinds, awnings, central vacuum system with attachments, built-in air conditioners, built-in appliances. The range must be there. Dishwashers, trash compactors, and remaining heated and cooking fuel stored on the property at time of settlement, and if owned, solar panels, windmills, water treatment systems, propane tanks, and satellite dishes. And if you're going to not leave something, put it under exclusion. Any questions? All right, paragraph 8. This is where we need to spend a little bit of time, I think. But paragraph
I have a question
8.
I have a question about fixtures.
Yes.
What about those solar panels that you have to wind up getting qualified for?
Well, then that says it here. If it's leased, then that's different. Then you're not. Look at this. That's where we go. The following items are not owned by the seller and may be subject to a lease or other financing agreement. Contact the provider, vendor for more information, i.e. solar panels, windmills. So if it's being leased, the seller should let you know here. It would say, so you would know, you would put the solar panel. So now I know that that's a lease, the solar panel is a lease. And if I want to keep them, then they need to give me the information to the provider. I contact them and I say either I want to keep them, and if I don't, you need to remove them.
Okay, so is that a contingency in the contract as well, or is that just?
No, it would just be, all you have to do is put here that if it's leased, you would just say solar panel. That means you, the buyer, know that this is a leased item, and if you want to keep it, you need to pay for it, and you need to sign a contract. So you need to contact the provider. So that's what this is saying. It means that, so when I walk in there and the solar panels are gone, then you can't say, wait, where are the solar panels? Well, you know that was a leased item. If you wanted, and your agent should point that out, or you should point that out that, hey, this solar panel is leased. You would ask the agent, can you give me the information to this solar panel company? Because my buyer wants to keep them. And then make your buyer into a new contract.
Right. But I had a client that I had to purchase. The reason I'm asking is I had to purchase what the buyer didn't want.
Okay. Then I'm assuming they removed them, right?
No, they didn't. It was a very difficult transaction. They removed it, and then wound up costing a buyer an extra $150 a month to lease it. Yeah, it got weird.
Well, see, but yeah, in that situation, if they don't want to have them and the lease has not expired, yeah, that can happen. But that's why you want to make sure what is happening in that situation, because that is possible. The contract's over another 10 months, the seller doesn't want, buyer doesn't want them, and now who's going to be paying? So if in that situation, I would have said, okay, seller, there's 10 months remaining. You want to pay, give the buyer a credit for those 10 months so the buyer can pay it for those next 10 months.
Makes sense.
All right.
Thanks. Yep.
Trent, before,
Yes,
Trent,
yes,
before
please
we-
go on. Yes.
Go on.
before we go to break, Mun has a question. How do you handle personal property and real property if the property has lots of statues and decorations in the lawn? Should a list be included and excluded, draw and signed?
Well, if they're just statues, they seem to me they should be personal property. I mean, I don't know. I mean, could some statues be, I don't think they could be anything but personal property. And it depends on how they are fixed to the property. I don't know the answer to that. Depends on how we know a personal property can be so affixed to the property that it becomes a permanent part of it. If they use cement to put it in, I don't know the answer to that. It depends. Just keep in mind, personal property, the difference between personal property and a fixture or real property. Personal property is something that can be moved without being disturbed. If I come into a house and I see a dining room table, I know it's personal because I can just pick it up and take it out the door. But if I come in and I see a microwave that's hanging over the I'm looking at my kitchen, a microwave over the stove, that's been attached to the wall. That is not personal property. It was personal property when I purchased it, but it's been attached to the building or to the wall, which now makes it real property, and real property is included with the sale. So just always remember, but it also depends on how that seller is using that item, because it could be personal property like a refrigerator that's been covered in cabinetry to match the cabinets. That's personal property. It's being used as real property. So my feeling is this: everything goes in your contract. If you have any questions about whether it's personal or if it's personal or it's real and it's either staying with the property or not, you put it in the contract. You figure that out on the front end, not on the back end.
Okay.
And
And may I
and-
ask? Yes, thank
Go
you
on.
for letting me ask. What if that is a fountain, water fountain, and it's already on the excluded list? But after the seller removed it, so what
They
is?
damage the lawn or something?
Yeah, because it's on. Yeah, it is. It's
Then
not on a lawn. It's on
do that.
something like a patio.
You do that on the front end. If you know a seller is going to be taking up a fountain, and you know as a real estate agent that it could cause some damage, or you know there's a big hole, you as the agent should figure out, all right, make sure that when they remove it, they fill in the hole. Maybe you want to fill in something else. But again, that's something as a real estate agent, you should negotiate on the front end. If I know they're removing it, then you need to figure out how they're going to replace it, how they're going to repair it, what are they going to do? Put it in a contract on the front end. Don't wait till they remove it and there's a big hole, and now the seller says, well, I told you I was removing it. Well, I would like you to fill in this hole. Well, I'm not doing that. That's why I'm a believer. I don't leave anything for chance. Everything is negotiated or figured out before, not after, before. All right. Don't wait till the end. Do it at the beginning, and you'll never have a problem. I can tell you, I've been an agent. I've been in this business 25 years, and I have never had a problem because I cover my bases. I'm not saying that other things can't happen, but on those type of things, cover yourself on the front end, and you'll never have a problem on the back end. I know it's time for a break, right, Cheryl?
Yeah.
yes.
Okay, thank you.
You're welcome. It's 10. What are we doing, Cheryl? Like a 10-minute break?
10-minute break.
All right, we'll be back at 10:50. All right.
Yeah, so
Let's see you guys.
10:46.
Wait, you 10:46. All right.
My computer clock is slow.
Yes, it's 10:40. So 10:50 we come back.
Carol, we're
10:46.
trying to, quick question for you.
Yes.
Will I be able to join from my phone? Because I have a couple like appointments and meetings. I
Yes.
didn't realize the time frame.
Yes, you can.
Just, okay, thanks. Have a nice day. All right, thank you.
Okay, are we back? Is it 10:30, 10:50?
Yes,
10:52 actually.
yes.
Okay, everyone, let's get back. All right, let's go to chapter 8. Any questions from anyone about anything?
So Catherine, it's going back to the co-op. Don't you think that including this with the agreement to sell can easily hurt your buyer's offer? Buyers have no idea that it hurts their offer. What's your opinion? It says that, I mean, the part including a commission.
Now, how would it hurt the buyer if you already negotiated with the seller? Because the only reason I would use it, if I call the seller and the seller said, the seller's agent said, I'm giving you $15,000 commission. Then I would use it and get the seller to sign it. And let me see. I've never, hold on a second. Do I use that? The seller sign, let me pull this form up because I never use it. So let me pull it up. I put it down here. Let's pull it up. All right. So I just want to see. I don't remember if they sell. Yeah. Okay. I was going to say you'd sell it. Okay. Yeah. So if I call the agent and the agent says, I'm giving you the commission is 15,000 and I signed it on behalf of my company and you signed it on behalf of your company, this is it. This is the agreement. So this would not hurt the buyer because you told me it's 15,000. I'm okay with 15 unless you mean, I didn't think of this, unless your contract says the buyer pays you 20,000. Is that that's what you mean? And this buyer and the corporating compensation is 15, the buyer still owes you 5. If that's what you mean. Now, if that's the case, you could then go back to the contract and add the 5,000. Let's say, using my example, that you agree the commission's 15,000. That's what the agent told you. The corporate broker compensation 15. You want your contract, the buyer is for 20. The buyer owes you 20,000. So the buyer says, well, wait a minute. Maybe you need to negotiate another 5,000 on my behalf, if that's what you mean. So then you put the 5,000 here to see if you can get, they've already agreed to give you 15. Now you asking for an additional 5. Maybe they'll give it to you, maybe not. If there's a really good offer, maybe they will.
Okay, Catherine has included here, couldn't get in touch with the agent before you put offer in. That's one way it could hurt.
Well, if you don't no, it couldn't hurt. If I don't get in front, let's say the buyer owes 20,000 to me. That's what my buyer agency contract says. I couldn't get in touch with the seller's agent. I put 20,000 here. That's all. How would that hurt the buyer? I want the commission to match what the buyer owes me. Because remember, I can't collect more than what's in my buyer agency contract. Remember that. Whatever the buyer agreed to pay you is a maximum you can collect from that buyer. So if, for instance, if the seller's giving you 20 and the buyer agreed to give you 15, you can't collect that other 5. You can go back to the buyer. So if you can't reach the seller's agent, put in the contract whatever you want and let them come back and say, we're not giving you 20, we're giving you 10. Right.
Okay, John has here, we're not specified. Can an electric range be removed by the seller?
An oven has to be included. So you saw that included, unless you mark it out, but it has to be included. And if it's a primary residence, the appraiser is going to expect the range to be in there. Otherwise, you're going to have an issue. So Yeah, let's go to paragraph 8. 'Cause I don't want to. All right, let's talk about buyer financing. Buyer may elect to make this agreement contingent upon obtaining mortgage financing. Now, if you go to paragraph F, if you're waiving it, you check that the sale is not contingent upon mortgage financing. If it's not contingent upon mortgage financing, can the buyer still get financing?
Yes.
Anybody? If you waive this, could the buyer still get a loan?
Yes.
Yes. If you waive it, it says buyer and the seller understand that the waiver of this contingency does not restrict buyer's right to obtain mortgage financing for the property. It just means it's not contingent. That's all. It's not contingent on the buyer getting finance. In other words, if the buyer waives this and they go try to get a loan and they can't, then they would simply lose their earnest money deposit, because you can't say, I was turned down for a loan, so I'm not buying it. No, this contract or this agreement is not based on you acquiring a loan, unless you put here, unless you check elected and you weren't able to qualify, then you will be able to, as long as you didn't do anything wrong, you will be able to get your money back if you didn't qualify for the loan. Now, if you are paying cash, now waiving, and let me give you one point that I think could help. If you have a buyer, especially if you talk about an investor who's paying cash, it is probably better that you put that is a cash transaction, because if it, I would go down to here and say something about this is a cash transaction, not, this is a cash transaction, not based on, and lend agent, I'm not around this. It's a cash transaction. And something about the seller is not, buyer is not going to obtain mortgage financing. Why would I put that? Because if I got multiple offers and they all waive the mortgage contingency, but those people may go get a loan, I don't want a loan involved. Because there's going to be an appraisal. So my seller still has to let someone in to appraise, even though it's not contingent on this. I would rather, if you're going to give me cash, put cash, and I know there's no finance, there's no appraisal unless you make it contingent. So I think if you strictly cash, say cash, because it's going to be a stronger offer. Does everybody understand that?
Yes.
So don't just put, so if you're waiving the mortgage contingency, and it's cash, put cash. All right, let me go back up to there. So, all right, so buyer will be in the fault. A1, buyer will be in the fault of this agreement if buyer furnishes false information to anyone concerning the buyer's financial and or employment status. Make sure buyers are providing truthful, accurate information to the lenders, to everybody. Otherwise, if they get turned down because they lied on the application, the buyer may be in the fault and may lose his or her earnest money deposit.
I have a question about that. I'm so sorry. I have a question about that exact line. So for a loan proposal or a pre-approval, if that does not have the buyer's name on that information, if it has someone else's name, is that considered false information? Would that particular line in the contract?
Well, whose name would be on it?
A lawyer. Let's say it's a lawyer's name. Or someone else's name.
Why would the lawyer's name be on the pre-approval? I'm just curious.
That's a good question, and that's what I'm facing right now.
Oh,
that's a very good question.
I would ask you to give me a pre-approval with the person who's purchasing the property. If the lawyer's his or her name should be on. I've never seen that. No, I would not. I would personally wouldn't accept that. I mean, when I present it to my seller, I say, well, the name of the buyer is John Smith, but there's Jill Johnson is on the pre-approval. So this pre-approval is no good. Or I would probably call the bank and ask, why is a different person's name? Unless maybe the attorney is buying it on behalf. I would contact the attorney or the bank and I ask why. Maybe there's a reason for that. But you would have to explain to me why, because my seller's not signing an offer with where is one person is the party, but the pre-approval's on a different person's name. I would definitely, that definitely is a problem.
Oh,
All right.
yeah. Oh, yeah. And that particular line that you just read, that covers that issue, I should say. I don't want to say cover, but it addresses that issue. The should
Okay.
buyer furnish false information or incomplete information, that is pertinent to the situation.
Then
right?
they may be in default, and the seller may decide that they're not entitled to an earnest money deposit back, and you all may
Okay.
end up in arbitration or mediation, because
Okay.
if that's the case, because if they
Thank
furnish
you.
false information. All right.
Yep.
All right.
Thank
You're welcome. Number 2, you have 7 days from the execution date to make a loan application. If you think it needs to be more than 7, put it. If it's going to be 7, again, I think it's a good practice just to type in 7. Because I know a lot of agents who just skip over that. They forget. This way, I know you looked at that. You looked at that, because maybe your buyer needs more than 7. Don't just skip over it, because it already says 7. If they find the 7, leave 7. But if they need more time, then give them more time. Number 3, seller will provide access. You need to make sure your sellers know that they have to provide access to insurers, representatives, and as may be required by the mortgage lenders, to surveyors, to the municipal officials, appraisers, inspectors. So even if they waive the home, even if you waive the mortgage contingency, remember you can still get a mortgage loan. So the seller would still have to allow the appraiser to come in. The seller can't say, wait, this is not contingent upon a mortgage, so I'm not letting anybody in. No, you still have to give access. And if you go back to this, it says buyer may elect to make his agreement contingent upon buyer financing regardless of any contingency elected. And that's this. Whether they elect waived or elected, these things apply. So the seller would have to provide access to these folks. And let's go down to this one. If you have an FHA buyer or VA, the property has to appraise for the purchase price or higher. Otherwise, a buyer can back out. So if the property is $300,000, the purchase price is $300,000, and you can see here it says the purchase price is stated in the agreement. If the property appraises for $290,000, there are 2 things you can do. What I always do is go back to the seller and say, hey, this property appraised for $290,000. I'd like you to reduce the price to $290,000. Seller could say no, and you could say, buyer, if you want it, you can pay that extra $10,000. So, all right, but the property has to appraise for either the purchase price or higher if it's an FHA or VA loan. If it's an FHA loan, you have to make sure both of those things, well, not both, this should be checked. Because the buyer has to get a protective, you could give them that. Technically, I think the lender is supposed to give them that, but we have it in our zip forms. I think the lender is supposed to provide them that for your protection, get a home inspection, but you should give it to them, because I think, if I remember correctly, the lender is required, the HUD rules require the lender to give the buyer that for your protection, get a home inspection before they sign an agreement of sale. So if the lender doesn't do it, and then you don't do it, then the lender may have to come back and say, hey, we're going to have to change the date on the contract, which may mess up all the execution date. In other words, give it to them yourself. Okay. Hopefully the lender gives it to them. When you sign a contract, give them the protect. All you have to do is download. It's on zip form. Protect your family, get a home inspection. All right. Now, if you elected a loan mortgage, then make sure they complete this. The loan amount, the number of years, is it 30 years, 15 years, the type of mortgage, is it FHA, VA? Make sure you complete this. If it's conventional, 80% LTV. Basically, the down payment to determine LTV, if your down payment is 20%, then your LTV would be 80. If your down payment is 10%, your LTV, loan to value ratio, would be 90%. If your down payment is 15%, your LTV would be 85. So here, if the LTV is 80%, it means the buyer is putting down 20%. Now, and here, interest rate, I could say I want the interest rate can be between 6%, and you have to put a maximum. This is a requirement. You can't leave that blank. Don't ever leave these blank. So the buyer is saying, I will take this loan from ABC Bank as long as the
All right, how
interest
about if I say,
is between 6%.
we discussed the ethics of recommendation and provided the family with the steps to
Hello.
enroll
Hello.
in family-based services when needed.
Hello. The lender, the buyer is saying, I will take this loan as long, when I put I'm sorry, I put ABC lender in the wrong place. It's ABC Bank here. I'm sorry. And this is the loan amount. Let's say 300,000. So I would so I'm willing to take this loan from ABC Bank as long as the interest rate is not higher than 6.25. If it's higher than 6.25, I can reject it. And I can say, I'm terminating this contract. And when I terminate it, I'm entitled to my earnest money deposit. This box is a number of points you're willing to accept, your buyer's willing to accept. I'm not willing to take more than 2 points. Remember, a point is equal to 1% of the loan amount. So if the loan amount is 300,000, 2 points would be 6,000. So if the ABC Bank is going to give me points that total more than 6,000, I could say no to this loan. Any questions about this? Any comments?
Can you discuss the commitment date?
Oh, I'm sorry. I didn't mean to skip that. So thank you. Yes, I do. All right, commitment date. Let's say settlement date is the end of the month. Let's say settlement date is April 30th. I believe it's best to have a commitment date. If the settlement date is April 30th, give yourself at least 10 days. I would probably put a commitment date of around the 21st. That's the date that the bank is saying to you, here's a preliminary commitment. And usually when you have a commitment, there are still conditions. So it may say you have to provide tax returns from last year. Now there are going to be items you can't clear until the day before, like the employment verification. That they're going to call the job maybe the day before, or 2 days before. But you want a commitment that gives your buyer enough time to clear the conditions on the commitment. All right. Is there a particular question you had about the commitment date? The person just asked.
Yes.
What is that?
So this isn't dealing with residential. This is dealing with commercial real estate. So if an individual who is purchasing commercial property, we get an agreement of sale and they're getting financing and that lender does not offer a commitment date, how would you handle that?
I don't know about commercial. I don't know. I've sold very little commercial property. I specialize in residential, so I don't know the answer to that. Maybe somebody else does. I don't know the answer. I just know.
In the off chance, in the off chance that similar scenario for residential, how would you handle that? Because to me, it's suspect. That doesn't sound right.
You saying if the bank doesn't give you a commitment date?
Correct.
Well, the bank wouldn't give you a date.
Or if they won't honor it,
because they may not honor it because your buyer's not doing what your buyer needs to do. That's sometimes why they can't give you the commitment date, because they don't have everything in. They figured that maybe the buyer never gave them tax returns. So they're like, well, we're not giving no commitment date. We don't have a title search in. We don't have the appraisal. They didn't pay for the appraisal. I've never seen in residential commitment dates, lenders don't give you the, I believe most lenders will give you the commitment as long as, I mean, they don't mind putting conditions because conditions need to be clear. They're going to give you the commitment. And remember, they have the contract. And as the agent, you should remind them that, hey, the commitment date is April 21st. We're at April 19th. How are we looking? I have not had a lot of problems with legitimate banks, I should say. Those, when I was doing business and they had all those fly-by-night companies and all these mortgage brokers, I had a lot of problems getting a commitment date. I don't know. Maybe other people are having problems. I think you just need to allow yourself time. And you, as long as the buyer is doing everything that buyer is supposed to do, I don't think you're going to have a problem getting a commitment date. I think you have a problem when the buyer is not living up to his or her end of the bargain. That's my opinion. Somebody else may disagree.
Thank you.
All right, let's go. Let's talk about now, if the seller does not, all right, let's look at number 2. The seller may terminate this agreement after the commitment date by written notice to the buyer if the seller does not receive a copy of the documentation demonstrating basically the commitment on the commitment date. They could terminate this contract. So you need to let the buyer know that. B, that they can terminate if the documentation demonstrating the mortgage lender's conditional or outright
Yes,
approval.
so that's basically.
There's somebody, Cheryl, are you there still?
Yeah,
Trent, I
she's
have a
muted.
question.
Okay. All right. The buyer.
Can I ask a question?
Yes.
I'm so sorry. Could you go back up to line number 161 where it says to exceed maximum interest rate of? Is there a standard there, or is it general practice or best practice to go like 0.25%?
That's up to you. I would probably, yeah, I always do. I usually do 0.5%, but you could do whatever. But you have to make sure your buyer is okay with it. Because
Right,
let's say your buyer says, I'm not willing. The rate's at around 3. I'm willing to go 3.25, but I'm not willing to go 3.5. So I always ask my buyer. But most of the time I put a 0.5 point, but I know the rates aren't going to go that high as long as my buyer is okay with it. Because remember, everything in here is protect your buyer. Because if your buyer may say the rates are 6%, I'm not willing to go higher than 6. That's it. They go high. They go any higher. I can back out. So you just need to ask a buyer. But I generally ask buyers to go up 0.5%, and I've never had a problem because I know, especially if they want the property.
Okay. And what about 165? Do you use the same principle there, 2%, or I don't know you have to ask.
I would use. Yeah, it depends on what the buyer is comfortable with. I explained to them that a point is equal to 1%. So 1 point is 3,000, 2 points is 6,000, 3 points is 9. Most of them say, whoa, I'm willing to do 1.5. But remember, you may already know what the bank is charging because you already have a loan estimate. So if you have a certain type of loan and you know they're charging 2 points, well, don't put 1.5. If you know that they charging 2 points, just going to put the 2 in there. Right.
Got it.
Well, you can put 2.5, but I would never put like 8 points or 6 points because that'd be crazy. But typically, your question, most of my buyers are okay with 2, 2.5, but 3 on something like this is 9,000. That to me, I think is a little predatory myself when you start getting above this. So I'm not that comfortable with it. But again, I don't make decisions. I just explain it to my buyers. They make the decision. But that's usually where I am, around 2, 2.5.
Okay, thank you.
You're welcome. All right, so back to this. Seller can terminate if they don't get the loan commitment, and if they get a commitment that has stuff in there that wasn't a part of it. Like if they get a commitment that says the buyer must settle on another property. Well, that wasn't a part of this. That wasn't a part of this contract, so we can just terminate it. But here's what you need to remember. If they terminate it, that's paragraph 4. If this agreement is terminated, the mortgage loan or the mortgage loan is not obtained for settlement, all deposit monies will be returned to buyer according to terms of paragraph 6, and this agreement will be void. So even though, so don't let anybody tell you that if they terminate it, your buyer, it will not get his or her money back. They will. All right. Obviously, we don't want that to happen. Now, here's one thing I just always want to point out. Let's say you're buying, you're waiving the home inspection. You're buying this property, no home inspection, and that's in 13. If you waiving, let's say you waiving all inspections, all right? Seller's happy because there are no inspections. Here's where sometimes agents will kind of mess this up. There are still 2 other inspections that must be done or possibly could be done even if you waive the home inspection. Here's one of them. If the mortgage lender, let's say you waive the home inspection, but the mortgage lender or the homeowner's insurance company requires repairs to the property, buyer will, upon receiving the requirements, deliver a copy of the requirements to the seller. Now, within 5 days, the seller has to decide whether the seller will make the repairs or not. So at the seller's expense. If the seller makes the repairs, then the buyer accepts the property and they release everybody from liability. 2, if the seller will not make the repairs or the seller fails to respond within the state in that 5-day period, buyer will then have the choice to make. 1, they can make the repairs themselves at the buyer's expense, or 2, they can terminate the contract and have their money returned. So sometimes sellers get upset with agents when they say, wait a minute, they waived the home inspection. Why am I now asked to do work? Why is FHA appraiser asking me to do work? If you want this truly to be you want to be as is, and the seller's doing no work, you better make sure you handle paragraph 8. What number is it? 8F5, because the buyer still has an opportunity to back out of this contract. Sellers may be thinking, oh, well, we're good because the inspections have been waived. Now, here's an inspection that's not been waived unless you waive it, unless you address it. Another thing, what's another reason a buyer can back out for another inspection that sometimes sellers aren't thinking of? What's another one, somebody? Anybody thinking, what about a U&O? If you need a U&O and you don't say that the buyer is responsible for the U&O and any costs associated with, well, here it says, paragraph 15, in the event any notices of public and or private assessments are received after the seller, and they talk about any violations when they talk about 10F, that's like violations, any kind of zoning, any housing, any zoning, any kind of violations are received after the seller signs agreement before settlement. Seller will, within 5 days receiving this notice of a violation, they would give it to notify the buyer in writing. Okay, seller gets a notice of violation from the county saying, "Hey, you need to do this work." After settlement, after agreement sale has been signed, the seller then has to either comply with the notice at the seller's expense before settlement, and then the buyer has to accept the property. But now number 2 says not comply with it. Seller says, I'm not going to comply with this. I was told this is an as-is transaction. I'm not going to comply with that. Well, then the buyer will notify the seller in writing within 5 days of what they're going to do, because now it's shifted back to the buyer, and the buyer has 2 options: to either comply with the notices at the buyer's expense or terminate the contract with their money returned to them. So those paragraphs, that number, paragraph 8F5 and this paragraph 15, you need to make sure if it's a as-is transaction and everything's being waived, and there's a mortgage, loan involved, that you address those 2 paragraphs. Does everybody understand that? Does this help anybody? Is this helping anyone?
Yes.
No?
Yes.
That one person, thank you. Can I get a second person? No. One person? All right.
Yes.
Yes,
Yeah.
it's helpful.
Yeah.
It's helping us.
helpful.
It's helping us. We listening.
All right, thank you. All right, all 3 of y'all, thank you. All right, any questions about what I just talked about? Any questions? That was a lot. Any questions?
May I ask, if the seller, if the buyer terminate the contract with no reason, then the seller could forfeit the deposit, right?
Right.
But what if the other way, the seller terminate
Seller
the contract?
decides not to sell the property. The buyer has
Yeah.
options
So
also. The
what
buyer can,
besides
remember,
yeah.
buyer can force the seller to sign the property. Remember from your real estate class, it's called a suit for specific performance. You could go to court and force the seller to sell the property because you have this is an agreement. This is a legally binding document. So if the seller says one day, you know what, I changed my mind, and I've had to remind sellers that, hey, the buyer could force you to go through with this. Okay. You can't just arbitrarily change your mind. And then they usually say, okay. I said, well, no, we can ask a buyer if you will let them out of the contract. Maybe you need to pay them something. We can try to figure it out. But if you just change your mind, you're breaching the contract, and there are consequences when you breach a contract.
So does it, excuse me, need to stay in the contract ahead of time, or is any part of this contract state how to handle that?
Yes, you can't breach a contract. Throughout here, it says the seller can't breach a contract no more. And there are different places in here, but just know that it's a contract. You can't breach a contract. No more than a seller can breach a contract. If the seller breaches it, the buyer can force them to comply. Just like if the buyer breaches it, the seller can force them to comply. Or in this case, we have what we call a liquidated damages clause in paragraph 26G. If the buyer defaults, and if you look at paragraph 26G, here's what I say. If you represent a buyer, I think it's a good idea to check this box, which says seller is limited to retaining those sums paid by the buyer, including deposit monies, as liquidated damages, which means that the seller cannot sue you for any more than what you put down as an earnest money. So if you put down 1,000 and you breach it, the maximum the seller can get is 1,000. If you put down 10,000, the maximum the seller can get is 10,000. So, but there are other things, and if you look at this, it says unless checked. Now, if this isn't checked, it says that the seller can do these different things. On account, they can, unless checked, okay, unless this is checked, they can only get their earnest money deposit. If this is not checked, then the seller may elect to retain those sums paid to the buyer, including deposit monies, on account of the purchase price, which means they can sue for specific performance too. They can force the buyer to go through with the contract, or as monies to be applied to the seller's damages. They say, I'm out 20,000 because of your breach. Well, I want you to pay me 20. Or as liquidated damages, they can say, you put down 18,000, I'll take the 18,000, and then we will void this contract. So it is a good practice if you represent a buyer to sign that. Now look at H. It says the seller retains all sums paid by the buyer, including deposits as liquidated damages, then the buyer and seller are released from further liability or obligation, and this agreement is void. So once you collect money, you keep the buyer's earnest money deposit as liquidated damages. You can't then come back later and sue for more. You can't say, well, I'm really out 30,000, and the buyer only had 15, so I'm gonna sue for an additional 15. You could, if this wasn't checked, but if this is checked, the only thing you can get, the maximum that you're entitled to as a seller is whatever the buyer put down as an earnest money deposit.
Yeah. And my buyer thought when I explained this G with them, and they thought that, okay, that is protected the seller. But for the buyer side, if the seller doesn't want to sell with no reason, then they don't have any compensation, because for the seller, they could keep their deposit. But for the buyer, there's nothing.
Well, they can't, wait, say that, okay, I'm sorry. So what can the buyer do? The buyer can sue them the same way. The buyer can make them go through with the sale. It's called, the buyer is called specific performance. If the seller does not, if the seller says, I'm not going to sell, the buyer can go to court and force a judge will make them follow through on this contract. That's what the buyer can do in the event that the seller breaches a contract. Because remember, there's no money for the buyer to keep, but the buyer can sue for specific performance. All right.
So if that means the buyer got to sue the seller in order for them to get their damage or whatever.
What's their
Is there
damage?
any?
The damage would
Means
be
the
their
money compensation.
Well, no, they'd be entitled to their money. If the seller breaches the contract, they're gonna get their money back. Even if they go to mediation, they're gonna get their money back because they didn't breach it. But you can also ask a seller, and this will
Sell
talk
the
about it
property.
here, but I want that the buyer, you can ask a seller to pay for any costs that you incurred. And this is here too. I want to get to it. I got too much more to go. You can ask a seller to pay for the inspection, the appraisal, anything you pay up front, because you should be made whole. If the seller breaches a contract, not only should you get your earnest money deposit back, but you should also get back whatever cost you put out. Like I said, like the appraisal, the radon, the termite, the home inspection. So you should be entitled to all those things too, because a buyer should be made whole because the seller was one that breached it. All right, let's go back up to where was I? Changes in financial status. Take a look at this. If you, paragraph 9, you should always tell your buyer, always tell them, do not buy anything. Do not go out and buy big ticket items before you close. If your car breaks down, you just have to wait until settlement. Do not go get a whole house full of furniture. Don't go get big new appliances, because it may change your income to debt ratios, and you may now not qualify for the amount that you were qualified for before you went out and made this big ticket item purchase. So it's best, and this says here, buyer, on paragraph 9, buyer understands that applying for and or incurring any additional financial obligation may affect the buyer's ability to purchase. So now this also talked about if the financial status of the buyer changes, then the buyer has to alert the bank and the seller. All right. So if they lost their job or their hours were cut, or it tells you if they make a new buyer having incurred a new financial obligation, like buying a new car, they should alert the buyer, the seller. And there's also, I need to find a paragraph where is the seller, if the seller, I think it's paragraph, if the seller's financial condition changes, then they need to alert the buyer. So, but let me get to that. Well, actually, that's going to be paragraph 14. If you, so it's kind of the 14. F. So you see, if the buyer's financial situation changes, they need to alert the seller. If the seller's financial status changes, it says if a change in the seller's financial status affects the buyer's ability, the seller's ability to convey title to the property owner for settlement, or an extension thereof, seller should promptly notify the buyer in writing. A change in financial status includes, but is not limited to, seller filing for bankruptcy, filing of a foreclosure lawsuit against the property, entry of a monetary judgment against the seller, notice of a public sale affecting the property, and the seller learning that sale price of the property is no longer sufficient to satisfy all liens and encumbrances against the property. And now you may have a short sale situation. So both parties must notify the other if there's a change in financial status. Any questions? All right. 10, if you're in the city, obviously it would be public water, public sewer. If you're outside the city, it may not, but all right. The only thing here I want you to see, paragraph E, the real estate seller disclosure law. Anytime you are selling residential property, not commercial, residential properties, not less than 1 and not more than 4 residential dwellings, 1 to 4 units. When it becomes 5 units, it becomes commercial. If you are selling any 1 to 4 unit, 4 residential dwelling units, you have to give the buyer a seller's disclosure. There are 10 exceptions to that rule. Like if you if there's a bankruptcy, if there is a foreclosure, you wouldn't have to. If you sell into a direct descendant, if there's a divorce, and if there's a new construction. So but now let me ask you, do you have to fill out a seller disclosure? I want to pull that up. If you are the executor.
No.
Anybody? If you're the executor, are you required to complete a seller's disclosure?
Yes.
Can hear me?
Yes.
Yes, you are.
But what if you don't know anything?
Just
Then
click
put
you don't know.
unknown.
Okay. All right. Here's a seller disclosure and answers. Now, here are the 10 exceptions. You don't need the law provides exceptions where a property disclosure statement does not have to be completed. All other sellers are obligated to complete a property disclosure statement, even if they do not occupy or have never occupied the property. Number 1, transfers by a fiduciary during the administration of the deed in estate, guardianship, conservatorship, or trust. I'm gonna come back to that one. Number 2, transfers of a result of a court order. You wouldn't require one. Transfer to a mortgage lender results from a buyer's default. That's a foreclosure. The bank wouldn't have to give you one if they took the property, or if you took the property in foreclosure. Number 4, transfers from one owner to another, not required. Number 5, transfers made to a spouse or to one of their children. Number 6, transfers between spouses as a result of divorce, legal separation, or property settlement. Number 7, transfers by a corporation to one of its shareholders. Number 8, transfers of a property to be demolished or converted to non-residential use. Number 9, transfers of vacant land, unimproved real property. Number 10, transfers of new construction. Now let's go back up to number 1. Transfers by a fiduciary during the administration of a decedent estate, guardianship, conservatorship, or trust. Well, that says that an executor does not have to fill one out. But here is what I need you to see. Look at this box. A lot of agents get this wrong. According to the provisions of the real estate seller disclosure law, the undersigned executor, administrator, or trustee is not required to fill out a seller disclosure statement. But look at the next line that's highlighted. The executor, the administrator, or trustee must, however, disclose any known material defects of the property. So even though you are the executor or executrix of the property, and it was your mother's property, for instance, and you paid to have the roof repaired when it leaked, you would have to disclose what you know. You don't have to disclose what you don't know, obviously. You don't have to go search. But if you know, for instance, when was a roof installed? Let's say, let's say was a roof or let's say repair. If it was or they replaced, repaired. So if you know it was repaired at some point, I can't check that, then you should check yes. Everything else could be no or I know. And then anytime you have a yes in the seller's disclosure statement, you have to explain it. You always have to explain a yes. Explain any yes answers, include the location, extent of any problems, and any repair or remediation efforts, the name of the person or company who did repairs and the date they were done. So, is there any questions about this? While I'm here, another thing that I think agents sometimes get confused. Take a look at paragraph 16. Some of you may have done this. This is, if I say the seller has to check off everything that's in this property. Let's say I put refrigerator. I checked yes. Some agents will then assume that the refrigerator is included in the sale. The only thing that's included in the sale is what's in the agreement of sale. Something on your seller's disclosure, something that's MLS, and MLS is not included unless it's part of the agreement. And if you look at this, because I think it says this section is intended to identify problems or repairs and must be completed for each item that will or may be included in the property. The terms of the agreement of sale negotiated between the buyer and the seller will determine which items, if any, are included in the purchase and sale. The fact that an item is listed here does not mean it is included in the agreement of sale. So, all right, is there any questions about this? All right, you all, am I losing you all? How long? You all can't hang to 3 until, what time is it? Oh, wait a minute.
No questions.
Here with me for another half an hour. I think we should go another hour because I ain't gonna finish. But I'm not gonna, I can't ask y'all to do that.
We have time.
All right, let's go back to, let's try to finish up. So there's a lot more I want to finish. All right, I'm gonna have to go a little faster, I think. All right, let's go to the their buyer's due diligence. Paragraph 12. Number 1, you should know that the seller will provide access. We already talked about that. Seller can't deny any access to inspectors, appraisals, any of that. Here's what I think that some agents, make sure you know this. Make sure your buyer understands this paragraph 12A2. Buyer may make 2 pre-settlement walkthrough inspections of the property for the limited purpose of determining that the condition of the property is as required by this agreement. Buyer's right to these inspections. All right. So you have, not counting your home inspection, you get to come back to this property 2 times, and you better leave one of them for the day of settlement for your pre-settlement walkthrough. You don't have the right to come back to this property 6 times, every time you want. You don't have the right to come in here and start bringing in your interior decorator and measuring drapes. That's why this says for the limited purpose. This is not the time to bring your aunt and uncle and all your cousins in to see the property that you buying next month. This is for you to come in to make sure repairs are done. Make sure things are done that are supposed to be done. That's it. Maybe you bring your contractor or your home inspector. This is not the time to bring 15 people with you. All right. Now the seller will have all heating and all utilities on for all inspections. If not, then you make them pay to have the inspector come back. Number 4, this is, now where's the one? Look at this one, which people don't realize is here. Look at go back to number 1. Only parties and their real estate licensees may attend inspections. Did you all know that's there? Only the people on this contract and their real estate agent can come in for the inspections. That means, now, I don't think a seller will say if the wife is buying and she's not gonna let the husband, they're not gonna let the husband come in, or vice versa. But if you're bringing in your mother and father and your best friends and your 3 and their children and your grandmother, that's a problem. If you want to bring somebody to the inspections, you should negotiate that up front. maybe you're the only one on the inspection, on the contract, and you want to bring your fiance, you want to bring your father. Well, you should negotiate that up front, because technically the seller can say, sorry, your fiance cannot come for this inspection. Your father cannot. Now, I can't believe somebody would do that, but they could. Now, I remember it was last year, because I was in Florida. It was during the winter, and out of property I was selling in Gaydon, and it was a single woman buying it, but she had a fiance, and they came with 15 people to the home inspection, because I got that angry phone call from the seller who lives in Jersey. It was her mother's house, and it was a beautiful single. But the neighbor called her and said, well, who are all these people in your house? She said, well, there's a home inspection today. She calls me and says, get those people out of my house. She brought her fiance, their 2 children, her mother, her father, her aunt, his mother, his best friend, her best friend. And then there was a home inspector there, the termite, and the radon. There were 15 total people in that house. So I had to call the agent and say, you need to ask all those folks, let the fiance stay, and they had 2 children, but I'm asking that everybody else leave. And that's what they had to do. That's all right. Let's go now. All right. This is if you're going to, here goes your different inspections. If you're going to waive, if you're going to elect it, that's your home inspection. If you're going to wait, you elect it. Oh, here's one thing I think is always a better practice. Don't use an X, all right? Don't use an X or check. Have your buyer initial here. I know I've never seen it done. I always have my buyers put their initials. Why? Because if you put a check and the buyer comes back and says, I don't remember checking, I waived the home inspection. I don't remember that. You sure you didn't put the check? I always say this, it's never a problem until it's a problem. If you have them initial, they waive the home inspection, there's no way they can come back and say they didn't do it. All right. I think it's the best practice to initial and not just stick an X or check. Anybody agree with that? Anybody think that's a good idea?
Yes.
Yes.
All right. Because sometimes buyers won't tell the truth. Okay. I've never met any, but sometimes they won't tell the truth. None of my clients have ever lied.
Trent, you skipped 12.5 where the seller receives a free copy.
Free copy of what? The
12.5. Yes.
Well, that's not 12.5. That's not the home inspection. 12.5. You know what? I purposely skipped this, but since you're so smart, I'm gonna come back to it. And you know what? I don't like this here, and I think this should not be here. And let me tell you why. Seller has a right upon request to receive a free copy of an inspection report. They're not talking about the home inspection here. They're talking about any reports other than the home inspection. You have to give the seller the home inspection report. That's mandated. That's why I think this is confusing. And it's funny, 2 weeks ago, a broker called me and we had this argument. He said, Trent, I don't have to give the home inspection to the seller. I said, you absolutely have to. And I said, go down. I'm gonna come back up. I said, go down to 13. I think that line should be removed. I think it's confusing. Look at inspection contingency. These are all your inspections. Take a look at these. All right. Let's say again, if you leave 10, I got 10 days to do all my inspections. All right. Here are the different options. Number 1, if the results of the inspections are satisfactory to the buyer will accept the report in their entirety. Will present the reports in their entirety to the seller. In their entirety. They accept the property. They said, hey, I'm not asking for any repairs. I'm happy with the property. But here's seller. Here's a copy of the home inspection report. By the way, I don't agree with this. Okay. Number 2, if the results of any inspection are unsatisfactory to the buyer, look at this. A buyer will present all reports in their entirety to the seller and terminate the contract. Hey, seller, I don't want this property because it has too many issues. But by the way, seller, here is the inspection report. Okay. Number three, the third option, if the results of the inspection are unsatisfactory to the buyer, buyer will present again all the reports in their entirety to the seller with a written corrective proposal listing corrections and or credits desired by the buyer. Here you're saying, I want the property, I'm satisfied with the results of the inspection report, but I want a repair credit, or I want you to put a new roof. So we're going to negotiate. Here's a written corrective proposal. So here's why that paragraph 12.5 is confusing. Well, is that you as the agent don't have a choice. You are mandated by this agreement to give the inspection report in its entirety to the seller, period. Who was it that asked the question? Who was that? I want to ask you a question. Who was that?
It was Dina. It was me, Trent.
Dina. All right. So Dina, let's go back up. Now, is that how you were reading this, Dina? This number
Yes,
5?
Yes, I wasn't, yes, I wasn't sure about that, given all
That's
the
how many
reports.
people read this. This is talking about any other inspection. So let's say your buyer did they wanted to test the water. So they did some inspection. Well, the seller's entitled to any inspections because it's their property. They have a right to know what's on their property. Obviously here, the seller is not entitled to a copy of the appraisal report. Now, I remember before they changed this, and I thought that was a wise thing to do because I'll never forget, probably maybe around 2005, I showed a property and I thought it was about $100,000 under price. I'm like, boy, this is a great deal. I don't think the buyer realized, the seller realized, I don't know, but we made an offer and we got it. And when the appraisal came back, it wasn't $100,000 on the price, it was $150,000 on the price. So I'm like, and then the seller's agent said, Trent, can you give me a copy of the appraisal report? Well, back then it said that the seller has a right to request, has a right to the appraisal request, appraisal report. All they do is request it. And I did not want to give that up because because that seller would have got to try to get out of that contract. So he asked for it. And I said, I did all my best. And I said, no, he called me and I said, okay, I'll do it. Just remind me. I think I did something like that on purpose. I said, no, I said, send me an email. That's what I said. Send me an email. And I'll send it over. He never sent the email, so I never sent it over. So he never got it. All right. My job is to protect my buyer, not to protect the seller. I was representing the buyer. All right.
Excuse me.
So
would you please explain the restriction and zoning? Because there are few times when my buyer select this one, then the listing agent asks why.
And I would ask why. Yeah, I would probably ask why too, because you really don't, you know why you don't really, you have to do whatever your buyer says, but the reason they probably asking, because the title is going to pick this up. That's probably why. Now, let's look at it. Buyer may investigate easements. Well, that's all going to show up in title. Deeds and use restrictions, they're going to show up in title, right? Now, the only thing that if I would say you probably need this, look at this part where it says, buyer may verify. Now you can use a zone and there's a zone and approval contingency, but buyer may verify that the property, present use of the property is permitted. So you may be using it as a multifamily, but it's zoned as a single family. But again, you had to disclose that in zoning. And if, you know, so so you may say, okay, they're using this property as a multifamily, but it's zoned as a single family. So I need to verify that it can be used as a multifamily. Or so I can see why, but most people will probably, and then the present use is used I think the only reason I would see why somebody would want this is that you're using the property illegally. So if you're using again as a multifamily, it's zoned as a single family, but you just
Yeah.
converted it into a triplex, but as a is legally zoned as a triplex. But I think that's going to show up in zone. So yeah, I don't know. I mean, I can understand, but I can see why most people say you really don't need it because zone title is going to pick this up and zoning. If the property's not, let me go back to say, if the property is used illegally as a triplex, when it's zoned as a single family, the appraiser's going to pick that up. The appraiser's going to come back and say, this is an illegal use. This property is not zoned as a multifamily, it's zoned as a single family, so it's used illegally. So you still, the buyer would not qualify for a loan, and the buyer could terminate it because he or she doesn't qualify for a loan. And if they terminate it based on not being able to qualify for the mortgage loan, they're entitled to their money, their earnest money deposit back.
But what if it's the cash deal? That is most of the buyer
They would be
because
entitled
they
to
take cash.
they're still entitled, whether it's cash or not. Wait, what? Say that again about the cash?
Yeah, if it's a cash deal, there's no bank or appraisal involved.
Well, then you should make sure. Then you should verify. Then you should be.
Yeah,
using this.
that was the reason.
Okay, well then
Yeah, but
then you should use that absolutely.
Okay.
If that's the case. All right, now let me go to inspection. Now, here's what I want you. This is important. All right, you have, if we leave it blank, you have 10 days to do an inspection. Okay, 10 days from the execution date. Don't forget, we don't count the execution date. If the seller signed it, the buyer signed it yesterday, the seller signed it today, today's execution date, you start counting tomorrow. All right, now you have 10 days to do your inspection. All right. After your inspection, and look at this, following, the word following the end of the contingency period, the end of the 10 days, you now have 5 days if you leave it blank, and leave it at 5, for a negotiation period. You have 10 days to do your inspection. Then you have 5 days to do a negotiation. Now, do you lose your time if you do the home inspection in 3 days? The answer is no. It just means you have a longer, you still have 15 total days. You don't lose your days. You have 10 days because remember, the negotiation period does not start until the end of the 10-day contingency period. So you may just be negotiating early, but you don't lose this 10 days. So you have 10 days to do your home inspection, and you never should wait till the 10th day, 9th day. And I believe it's best to get it done in the first day or two because things could happen. All right, so after 10 days, we start or before, but we following the end of the contingency period, we can start a negotiation period. That means we're negotiating repairs or credits. Now, during the negotiation period, number one, the seller will acknowledge in writing the seller's agreement to satisfy all the terms of the buyer's proposal. Seller says, I'm gonna do everything you ask. You want a new roof, you want a new heater, I'm doing it all. Or number two, buyer and seller will negotiate another mutually acceptable written agreement providing for any repairs or improvements to the property and or any credit to buyer at settlement. So the seller will either accept the proposal as it is and agree to do everything, or they will negotiate. Now, if the seller agrees to satisfy all the terms of the buyer's proposal, then buyer will accept the property and release them from liability. Now look at B. If no agreement, no mutually acceptable agreement is reached, or the seller don't respond during that 5-day negotiation period, within, if you leave it as it is, it's 2 days. Within 2 days, following the end of the negotiation period, remember you had 10 days for the contingency, to do the home inspection. After the contingency period is over, you have 5 days for the negotiation period, and following the negotiation period, within 2 days, the buyer will do one or two things. The buyer will accept the property as it is, or they will terminate the contract. That is, if they can't reach an agreement during that negotiation period. Buyer says, okay, I'll just accept the property and I'll make the repair. Or I'm gonna terminate this and you have to return my deposit, my earnest money deposit. Any questions? Any comments? All right, let's go with the, okay, let's go down to title. Now, this is one where I think this number is, I would always change this. I think this number is way too low. 7 days. This agreement says you have 7 days to do a title. Well, if you got 10 days to do a home inspection, most people aren't ordering title until after they know if they're going to buy the property, because of course, a contract, I mean, a deal's going to die during the home inspection period. I mean, based on what's in the home inspection. I'm not ordering a title before I know if the deal's going through, because most title companies, well, mine wouldn't. I mean, if you do business, they probably won't, but a lot of title companies will charge a cancellation fee, and that the buyer may have to pay that $125, $150 fee. Well, even if you don't put a 15, you put a 10, because by then you probably know, or 12, you know whether or not you all are moving forward with this transaction. Does everybody agree with that? That 7 days seems awfully soon, too soon to be ordering title?
Yes.
Yeah.
Now, why would somebody want 7? Well, it's possible that you would want to get it done right away, because you may find out the seller has some clouds on the title, and it gives them more time to cure those. I don't know. I mean, that's maybe one reason, but I usually want about 15 days. All right. Now, let me see. What happens, let me ask you, if the seller, you find they do the title, the seller has they owe too much money and they can't sell the property, are you entitled to get all the monies back that you put out for any inspections and all? Anybody? Everybody's sleeping on me now.
I said
you
yes.
are.
Can you repeat that question? Can you repeat
Yeah.
the
If
question?
you,
please?
the seller, you ordered the title report, and the title comes back that the seller owes $100,000 more than what they thought, and now they don't have enough money to sell this property. They're going to be short, so the deal's going to die. You paid for an appraisal, you paid for inspection, you paid radon, termite. Does the seller need to reimburse you for all those costs that you incurred?
Yes.
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 The answer is yes. And you want to see this in the contract, and you should know that is in 14G. Take a look at 14G. So you know that if you ever come into this, if seller is unable to give good and marketable title that is insurable by a reputable title insurance company at regular rates, buyer may terminate this agreement by written notice to the seller with all deposits returned to the buyer. Now go down further. It says upon termination, all deposit monies will return to the buyer according to paragraph 26 of the agreement, and seller will reimburse buyer for items specified in will reimburse the buyer for any costs incurred by the buyer for any inspections or certifications obtained according to the terms of the agreement. And for those items listed in 14C, if you look at 14C, then 14C, look at the items that are title search, title insurance, or any title cancellation fee, flood insurance, fire insurance, hazard insurance, or any cancellation fee, appraisal fees, and buyer's customary settlement costs. And remember, it says any inspection, so I would say to you on home inspection, radon, termite, they would be included. Okay, so if the seller's not able to give you good mark, can't close because of something on title, then you should ask your buyer to submit a letter to them, asking to be reimbursed. Any questions? All right, I kind of went through 15. If now look at 15B. I don't want to if you have never mind, let's go. All right. Let's go to condo. Let's go to condominium. If it's not a condo, clearly you would just, if it's a condo, and I've sold a lot of condos in my day. All right, if you're selling a condo, that property, this first of all, the seller's disclosure, when you do a seller's disclosure for condo, it's only for what's inside the walls. It's not anything outside of your unit. So you don't have to worry about what the wall, what the roof's like, or what the common elements are like. Only what's in your unit. All right. Now, look at this. The property is a unit of condominium that is primarily run by a unit owners association. Section 3407 of the Uniform Condominium Act of Pennsylvania requires sellers to furnish buyers with a certificate of resale and copies of the condominium declaration, the bylaws, and the rules and regulations of the association. Now, this is important if you ever sell condos, all right? Look at this. Now, this is there's a new unit, but let's say if it's a resale, all right? Within 15 days. Now, this is a law, so this is not changed. Can you change this? I guess you can. No, I guess you could change that. You can't change this 5. All right, let's say within 15 days of execution agreement at the seller's expense, the seller will request from the association a certificate of resale and any documents necessary to enable the seller to comply with this act, the Condominium Act, the Uniform Condominium Act of Pennsylvania. So the seller needs to order the resale certificate within 15 days. The act also provides that the association is required to provide these documents to that seller within 10 days. Now, if you're selling condos, what you should always have your seller do is order these documents ASAP, because once the buyer receives these condo docs, the buyer by law, and if you see this 5, it cannot be changed because that is the law. The act provides that the buyer may declare this agreement void at any time before the buyer receives the association documents and for 5 days after receipt or until settlement, whichever occurs first. So you want the documents in the buyer's hands ASAP, because the buyer has 5 days after receiving them to decide whether or not they're going to go forward, because they may see the documents, the condo documents, and say you can't rent. Well, you say, well, wait a minute, I was going to use this as Airbnb. Well, I don't want to buy this. I live here on the beach, my condominium, and I bought it not meaning that I wasn't planning to rent, but I can't rent. Now, if I bought this unit because I wanted to be able to rent it out when I'm in Philadelphia, I wouldn't have bought it.
Hey,
And
Liv.
it tells you the fee
day.
in
How
my
are you?
unit, if you rent in my building, Airbnb, anybody, is $1,000 a day fee penalty for every day they rent it from you. And all the money you collected from them, you must turn over to the association. That's the first time you get caught. The second time is $5,000 for every day they rent it, plus you have to turn over all the money. The third time, you have to turn your condo over to the association. So you imagine not a lot of people trying to rent, right? All right. Any questions? So if you're if it's a condo, please get the condo docs ASAP. All right, get the condo docs ASAP. What time is? Oh, it's after 12. I'm so sorry, y'all. Maintenance. Let me just finish up. Make sure the seller maintains the property in the present condition, normal wear and tear accepted. You cannot, ruin the property. Home warranty. I'm not going to say. FERPTA. You've heard a lot about FERPTA. FIRFTA just means that it's a foreign company or a foreign person is purchasing the property. That could be a foreign company. When a foreign person is purchasing, is selling real estate, not purchasing, selling real estate, the IRS imposes a tax on that foreign person. And if that tax is not paid, then the buyer will be responsible for that tax. All right. So FIRFTA, but again, I think the title company would know whether it's a foreign company. But if you know that the seller, and you should be disclosing this, and I see it in MLS, if you know your seller is a foreign person or foreign company or foreign national, you should put that in MLS, because if it's a foreign person, then they have to withhold taxes. And if the taxes aren't withheld, the statute says the buyer then becomes responsible for paying those taxes, those withholding taxes. And I'm gonna default, we kind of went through that. Mediation, we kind of real estate recovery. So I think that's about it. Just make sure buyer has signed the consumer notice. The buyer's received, you have to always give a buyer estimated closing costs. If there's a co-op, there should be a deposit money. Deposit money just says who's going to be holding that buyer's money. They should know. Anytime your client, your buyer is giving you a check that's going to be turned over to someone else, there has to be a notice for the buyer, so the buyer knows who is holding his or her money. The buyer has to have, you make sure, oh, you know what, the lead-based paint addendum, that's a part of this contract. I know a lot of times we send it with the seller's disclosure, but this is, it says the buyers receive the lead-based paint addendum, which is attached to this agreement of sale. And also the buyer has received to protect your family from lead. So make sure your lead-based paint addendum, that is, if the property is built before 1978, is a part of this contract. So that's attached here. So anytime, and most people don't do it, they send it separately and all, but you should be sending over the lead-based addendum with this contract, because it says it is attached. The lead-based paint addendum is attached to this agreement of sale. Any questions, any comments?
Thank you, Trent. I always take this every time you teach it. I learned something. I got my little notes written on here. Thank you. It's always a good refresher to know,
Well, thank you. Thank you. I'm glad to hear that. Anybody else learn anything today?
Yes,
Thank you,
thank you
Dana.
so
You were the only
much.
one, but I appreciate it.
Yes, thank you.
All right, everyone. Any questions?
Okay, Trent, so thank you once again for your expertise today. And thank you to the GPAR members for joining us today, and have a great weekend.
Thanks.
Enjoy.
Good weekend, everybody.
Cheryl, did you see what she wrote? Can we access the recording? It's going to be on
Yes,
YouTube.
Yeah, you'll receive an email with, buttons to go to YouTube, Spotify. It should be on our website, gpar.org. Okay?
Thank you.
So
This
thanks
was
again.
excellent. Thank you so much.
You're welcome. Thank you all. Have a great day.
Thank you.
It's 85 degrees. I'm going out into this 85-degree temperature. I got to drive down to Miami. And all right. Thank you all. Have a great day.